This video is for educational purposes only and does not constitute legal advice. For advice about your specific situation, please consult a qualified attorney. Some of the content was created with the assistance of AI.
Your complaint is dismissed for failure to state a claim.
Did you know that a large percentage of federal civil cases are dismissed at the very beginning, often for failure to state a claim? Motion to dismiss is a powerful tool in civil litigation, and understanding it is essential. In today's session, we will explain common mistakes pro se litigants make in their complaints, what a complaint should include to survive a dismissal, the process of amending a complaint, and other procedural aspects of Rule 12b-6 motions. Rule 12b-6 provides that a defendant can move for dismissal on the grounds that the plaintiff has failed to state a claim upon which relief can be granted. In practical terms, the court asks, even assuming the allegations are true, do they establish a legally cognizable claim? To survive, the complaint must allege sufficient facts, not just conclusions, and clearly state each element of the claim being asserted. If either requirement is missing, the court will dismiss the complaint. Let's put this into practice. On the screen, you see a complaint for breach of contract. A complaint has a few required sections, including factual allegations and claims. These components play a crucial role in the court's decision on dismissal. The judge first looks to see if the complaint contains sufficient facts to support each element of the alleged claim. Remember, facts mean events, dates, and the parties involved. In other words, what really happened. But many pro se litigants mistakenly put their own thoughts, arguments, or even legal citations into the factual background section, which is not designed for that type of allegation. Here's how the test works. The judge reads the facts. Then he looks at the claim you assert. Next, he checks the elements of the specific cause of action you are asserting. In our example, we have a claim for breach of contract. So, let's see what elements are required for this type of claim. We turn to the jury instructions, which provide both the elements and relevant case law citations. If you don't have jury instructions, you can look up case law that identifies the elements of the cause of action you are asserting. Once we have the elements, we compare them against the complaint. In breach of contract, there are 4 required elements. First, the existence of a contract. Second, the plaintiff's performance of the contract or a valid excuse for non-performance. Third, the defendant's breach. And finally, damages suffered by the plaintiff. Only if all elements are clearly stated in the complaint and supported by facts will the claim survive dismissal. Now let's test our example. The first element is the existence of a contract. As you can see, paragraph 27 states that the parties entered into a contract and provides details about it. This statement is based on the factual background section, which includes more specifics about the agreement. So, our claim passes the first element. Next, the second element, the plaintiff's performance. Paragraph 29 states that the plaintiff performed her part of the agreement by making the required payments. This sufficiently pleads the second element. Now, the third element, the defendant's breach. Paragraphs 31 and 32 describe how the defendant failed to uphold the contract. Finally, the fourth element, damages. Paragraph 33 identifies the damages suffered by the plaintiff. Since this complaint for breach of contract includes all 4 required elements, each supported by factual allegations, there is a strong chance that the claim will survive a motion to dismiss. Remember, at the pleading stage, providing evidence is not required. But the plaintiff must state sufficient facts, and in many jurisdictions, the court will treat those facts as true for the purposes of a motion to dismiss. Here are some of the main mistakes often found in complaints. First, vague allegations, general statements such as, the defendant discriminated against me without specific supporting facts. Second, failure to identify a legal basis, stating allegations without connecting them to any legal rule. Third, reciting legal elements without facts, simply listing statutory language without accompanying factual allegations. Finally, conclusory statements, assertions such as, the defendant intended to defraud me, without describing the conduct that demonstrates fraudulent intent.
Wow.
Amending a complaint gives a plaintiff a chance to fix deficiencies and strengthen their case before dismissal. Here are a few tips regarding amendment. Check the opposing party's response and note the deficiencies you need to fix. Add specific facts and ensure each claim element is supported. Amendments are limited to address all issues carefully in one revision.
Motion to dismiss is denied.
Welcome to Justice Matters,
where we discuss the legal issues shaping our world.
Welcome back to Justice Matters. I'm your host, Sarah, and today we're diving into one of the most important, but sometimes overlooked procedural tools in federal litigation, the motion to dismiss under Rule 12b-6. Joining me is Professor Michael Harrington, a scholar of civil procedure and federal courts. Professor, thank you for being here.
Always a pleasure, Sarah.
Let's start with the basics. What exactly is a Rule 12b-6 motion?
Sure. Rule 12b-6 allows a defendant to ask the court to dismiss a lawsuit because the complaint doesn't state a claim upon which relief can be granted. In plain English, it means even if everything the plaintiff alleges is true, the law still doesn't provide a remedy. It's less about the truth of the facts and more about whether those facts add up to a legally recognized claim.
So it's a kind of gatekeeping tool for the courts.
Exactly. It prevents meritless cases from moving forward into expensive discovery and trial. Historically, this was called a demurrer, and Rule 12b-6 modernizes that idea.
Timing seems crucial here. When do defendants usually file this motion?
It's filed very early, before the defendant answers the complaint. That makes it a strategic move. If granted, the lawsuit could end right away. And even if denied, the motion gives the judge a preview of the defendant's legal arguments and signals to the plaintiff that the defense is ready to fight.
But the standards for deciding these motions have shifted, right?
Yes. For decades, the standard came from Conley v. Gibson in 1957, which said a case should only be dismissed if there was no set of facts that could entitle the plaintiff to relief. That was a very lenient threshold. Almost everything survived.
And then came Twombly and Iqbal?
Correct. In 2007 and 2009, the Supreme Court changed the landscape. In Twombly and Iqbal, the court said complaints must state a claim that is plausible on its face. Conclusory statements like the defendant was negligent don't cut it. Plaintiffs must plead enough factual content to make liability more than just possible. It has to be plausible.
That sounds like a higher bar.
It is. Judges now act as more active gatekeepers. They strip out bare legal conclusions, then ask whether the remaining facts plausibly suggest wrongdoing. This can be tough for plaintiffs, especially in cases where key evidence is in the defendant's hands, like discrimination or corporate fraud.
So if a motion to dismiss is granted, is the case over?
Not always. Often the court dismisses without prejudice, meaning the plaintiff gets a chance to amend the complaint. But if the problem is incurable, say the statute of limitations is run out, the dismissal might be with prejudice, which permanently ends the claim.
I imagine both sides have to think carefully here.
Absolutely. Plaintiffs need to front-load their complaints with facts, not just conclusions, to survive the plausibility test. Defendants, meanwhile, have to weigh whether filing a motion is worth it. If the flaw is minor and easily fixed, a motion could just help the plaintiff strengthen their case.
So, in short, Rule 12b-6 is both a sword and a shield. It can cut off weak claims, but it can also backfire if used unwisely.
That's a perfect way to put it.
Professor Harrington, thank you for breaking this down. It's a reminder that sometimes the outcome of a case hinges not on the jury or trial, but on the very first battle over whether the complaint even makes it through the courthouse doors.
My pleasure, Sarah.
And that wraps up this segment of Justice Matters. Stay tuned for more conversations on the forces shaping our legal system.
If you enjoyed this video, don't forget to like and subscribe. Your support helps us create more content like this for you.